Hello again and welcome back. This installment is going to be focused on litigation. I hope that all of you have read the assigned chapters in your textbook for this subject matter. It's very detailed. It's got a lot of components, and we're going to walk through some of the major points that I'd like you to be aware of and make use of in terms of your studies. Litigation is a dispute resolution mechanism. Historically, it's a method by which cultures have developed to allow judicial-based decision makers, that would be judges, to decide disputes. And decision makers also would include, of course, juries, when there is a judge present to direct them, of course. Over time, systems have been put in place and procedures developed to facilitate judges to adjudicate, and I put that in quotations, adjudicate the dispute amongst parties. To adjudicate means that a formal judgment or decision about a disputed matter will be rendered. For a dispute to be adjudicated, the parties in the litigation process must have standing to sue. Standing to sue. Courts cannot litigate disputes when there is no connection to the law. A plaintiff must have a so-called stake in the dispute in order to commence the litigation process. There must be some basis by which the plaintiff has the right to proceed in the litigation. That would be, for example, a cause of action. And that cause of action directly impacts the parties and has been impacted by the actions or inactions of the defendant. So let's say, for example, a plaintiff has been involved in an auto collision with the defendant and is alleging that the defendant in litigation was negligent. The plaintiff has a standing to sue the defendant because the actions occurred involving the plaintiff and the defendant and also implicated the rule of law. That rule of law is something we're going to study later on in this course, the law of negligence. However, there would be standing to sue the defendant based on the application of law and the parties involved which have a connection. Now, let's say that Ann is the plaintiff, Bob is the defendant, and they were the only two individuals involved in this so-called collision. Ann is contending that Bob was negligent in the operation of his vehicle, causing the damage that resulted and the injuries caused by the alleged negligence. Let's say that Clyde happened to hear about this collision between Ann and Bob. Clyde wasn't a passenger, Clyde wasn't an operator, Clyde had no involvement whatsoever in this matter. Now, would Clyde have standing to sue? No. Clyde has no involvement, Clyde has no stake in the dispute, so Clyde would not have standing to sue. But obviously, with this simplified example, Ann would. The court must have jurisdiction over the parties in which to adjudicate the dispute. The party who files the action in the litigation process is the plaintiff. Remember, in our previous discussions, I mentioned how important terminology is. We need to know who these terms apply to and by which relationship that it impacts the law. Now, the party sued would be the defendant. Defendant is a term, plaintiff is a term. We need to identify these terms, and your authors do it very easily for you in the textbook. They darken the print in the textbook chapters. So whenever you see darkened print, that's a key term. You need to define and understand that term. And at the end of the chapters, again, I've said this before, there's a whole listing of key terms and the corollary pages in which they're found within the chapter. Make sure that you understand the key terms. It will help you study for the course. It will help you better understand how the law is applied to all of these matters, and will give you, I think, a much better or much higher level of satisfaction knowing that you are really studying and understanding what is there for you to make use of. So let's talk about some terms. The complaint. The complaint. And you might want to take a look at figure 4.1. Figure 4.1 in your textbook. It might be on page 104 with some of your editions, or page 96 and others. But there is a pretrial procedure which is outlined in this form. The complaint is a term. It's part of the pleadings. The complaint contains the allegations by the plaintiff and a statement about what the case is all about, and the request for some form of relief. A summons is another term. The summons is actually a form of a court order. The summons and the complaint are served on the defendant. And once the summons and the complaint are served, the summons the defendant to appear in court or at a designated time within the judicial system to respond to the complaint allegations initiated by the plaintiff. And that response can include a variety of mechanisms. For example, the response might include a so-called motion to dismiss, where the defendant does not believe that the complaint contains the right legal claim or the theory for relief, and needs to be addressed by the court before the case can go forward. A motion to dismiss is a mechanism in the litigation process that the defendant has to use in order to combat or try to defeat the complaint and the case moving forward in the litigation process by the plaintiff. Now let's assume, for example, as an example, a statute of limitations applies to the cause of action. The statute of limitations would be the time frame in which the legislature has stated this is when a case must be filed timely in order to avoid it being late or untimely based on a statute of limitations. In a personal injury case in our jurisdiction here in Illinois, a 2-year statute of limitations applies. If it involves a breach of an oral contract, there's a 5-year statute of limitations. If it's a written contract, it's a 10-year statute of limitations. And there's different limitation periods which govern different types of causes of action. A motion to dismiss by the defendant might argue, for example, that the complaint was untimely filed and barred by the statute of limitations. Let's assume we move past the statute of limitations as an example, and all the motions to dismiss have been ruled upon by the court, and the court has said, case goes on. Well, then it's time for the defendant to answer. An answer is a formal litigation mechanism wherein the defendant has to respond to the allegations in the complaint. Now, if the defendant agrees to all the allegations in the complaint, then there is no further dispute and the case can be resolved. However, chances are probably pretty good that the defendant is not going to agree to all of the allegations raised by a plaintiff in the complaint and will deny some of those allegations. And when the denial amounts to a dispute being considered and the court believing an actionable claim exists and a defendant is entitled to a defense, then the answer is filed and the case moves forward. Now, a defendant can also consider filing a counterclaim against the plaintiff. A counterclaim would be, for example, where another matter arising out of the same circumstances between the plaintiff and the defendant could be alleged by the defendant claiming liability. Well, that's a term, liability. Liability is legal fault, legal responsibility. The defendant could counterclaim that the plaintiff, for example, has breached a duty or has breached a contract or has done something which warrants an independent claim against the plaintiff by the defendant. And in that instance, the plaintiff would be the counter defendant, and the counter defendant, or the defendant literally would be the counter plaintiff. So that information is contained in your textbook reading, so make sure you're aware of these terms and how they apply to this process. For a court to have the authority to adjudicate a dispute, there must be personal jurisdiction over the parties. The plaintiff must have standing to sue. Personal jurisdiction over the defendant occurs when a summons has been served requiring the defendant to appear in court and respond. And that response can be by way of a motion to dismiss or an answer and so forth. Historically, the summons could only have been served to compel jurisdiction over the defendant within the borders of a particular state. Courts have enacted, I shouldn't say courts, legislatures actually have enacted, which the courts apply, long-arm statutes to allow for service beyond their boundaries, beyond the boundaries of the state. However, there must be some connection by the defendant to the cause of action within the state's boundaries where the plaintiff commences litigation. Long-arm statutes permit a court to obtain jurisdiction. Remember, jurisdiction is another term that you need to understand so that you can apply that understanding to a set of circumstances or facts. Well, what would be an example of that? A lawsuit's filed. The plaintiff initiates the claim in case litigation, tries to sue the defendant. The defendant is served with summons and complaint. There must be jurisdiction, which is the power of the court to adjudicate the dispute over the defendant where the process is served beyond the borders of the state where the court is situated. That's what long-arm statutes permit, is a court to obtain jurisdiction over the defendant even where the process is served beyond the borders. So in other words, if a matter arose in Indiana, but the plaintiff is in Illinois, can there be a long-arm jurisdiction imposed? If the cause of action occurred in Illinois and the defendant resides permanently in Indiana, would that be a situation where the long-arm statute permits a court to obtain jurisdiction? So those are points that need to be considered and understood, and the reference between the states is just an example. So long-arm statutes permit a court to obtain jurisdiction when, one example would be when the defendant has minimal contacts within the state by having committed a tort within the state. Now we'll learn what a tort is. We've already talked about it to some extent. It's a civil wrong for which damages are allowed by a remedy that the law recognizes. But minimal contacts within the state. Number two, the defendant owns property within the state that's the subject matter of the dispute or the lawsuit, obviously. And 3, the defendant has entered into a contract within the state or transacted business that is the subject matter of the lawsuit within the state. This is a quote that's found in the margins on one of the pages in your textbook. And I like this quote, and it's, I think, extremely meaningful, which is why the authors selected it and why your editors made it contain in your book. The quote is, "Justice is the great interest of a man on earth." Now, obviously, this was by Daniel Webster many, many years ago. It wouldn't be today where the term man or woman would be used. It would be justice is the greatest interest of one or a human or a person on earth, something that is non-gender or gender neutral. But anyway, the quote I think is really apropos. It is the ligament which holds beings and civilized nations together. Just think about that. Obviously, with litigation, we have a process in which justice can be administered. This is a term that you learned about in earlier chapters, procedural versus substantive law. Examples of substantive law would be contract law, employment law, property law. Procedural law, however, deals with procedures and process. When we study litigation, it is procedural law that has to be understood, and procedures or rules, court rules, need to be applied so that the substantive law can be determined by a trier of fact. That would be a judge or a jury. So we've got procedural laws, which we're studying and which you have been introduced to in great detail in this chapter, and substantive laws, which we're going to continue to study as this course unfolds. Again, look at figure 4.1 in your textbook. That really outlines a pretrial procedure in terms of most of the major settings or available options within a litigation process before trial. Before trial means pre-trial. So you'll see on figure 4.1 much of what we've already discussed. Plaintiff files a complaint. The complaint and summons is served on the defendant. The defendant files a motion or answers with possible counterclaims or defenses. The court rules on the motions. The plaintiff files a reply to the answer. And then the attorneys conduct discovery. And we're going to turn next to what is discovery. And then ultimately the parties still in a pre-trial status before the case goes to trial can file other motions. Motions, for example, for summary judgment or judgments on the pleadings, which we'll talk about in just a moment. And then right before the trial begins, there's a so-called further pre-trial procedure, and that would be a pre-trial conference where the judge has literally a conversation with the parties, primarily their attorneys. Sometimes the parties are involved, and they discuss what will take place based on the evidence and the rulings, the procedure at trial. So let's talk about discovery. Let's talk about steps in discovery and the litigation process generally as it moves forward into this so-called discovery stage. The aim of modern rules and procedures for discovery is to avoid surprise. There's a term that I put here on this PowerPoint, no more trial by ambush. Well, what does that mean? It means being surprised at trial, not having the information that, had it been available, might have steered the parties in a different direction or allowed the attorneys to consider or implement other actions or procedures or strategies. Discovery is the process or means in litigation designed to ensure that each side, both the plaintiff and the defendant, are fully aware of all of the facts involved in the case and the intentions of the parties. In other words, where the lawsuit is going, what direction it will take place, and why. There's a lot of tools that can be used in the discovery process. And in your textbook, there are examples of these tools, methods, in other words, that can be used so that information can be gathered, so that the parties' intentions can be understood, so that the so-called trial by ambush never occurs. Today, our modern courts allow the parties, through their attorneys, to use all these tools, all again with the aim of understanding the case, the facts in their entirety before trial begins. And often, in today's modern litigation setting, very few cases, believe it or not, very few cases actually go to trial today with a trial by judge, which is a bench trial, or a trial where there's a jury trial. Because the parties have had the chance along the way, so to speak, to consider the defenses, consider the merits of the claim, and perhaps have a settlement or address ways in which the court may dismiss, when appropriate, the case from even moving forward to a trial. So there are tools that you're going to need to understand. Interrogatories are questions that are submitted to the parties. There are written interrogations, if you will, where each party is obligated to provide written information responding to the inquiries about the case. For example, where did the collision occur? Who was present? Who are the witnesses? What are the damages? Has the plaintiff, for example, lost any wages as a result of the injury occurred? Or if the case involves a contract, who was present when the agreement was reached? In what form was the agreement based? In other words, information that allows the other party to better understand the claims and intentions of the other, so that all the information can be understood before trial begins. Requests for production of documents. In many cases, there are documents that need to be exchanged and understood, which form the nature of the claim or the basis of the action. Our courts allow for a discovery request for the production of documents. Today, documents are not only in written form based on material disclosures, but it also might involve electronic evidence. Not necessarily in paper form, but electronic evidence. A good example of electronic evidence would be emails or text messages. Can those be included within the so-called request for the production of documents as a discovery tool? The answer is absolutely yes. A request to admit is another tool. It's a tool that allows either party to request of the other party an admission to certain stated facts. Well, if certain stated facts are admitted by the parties to the litigation, then there may not be a need to move forward with other forms of discovery. And it could be that if the parties admit to certain stated facts which are in dispute, then there may no longer be a dispute by which a trial is needed, or maybe on a particular element of evidence that admission could save time at trial for a particular point that needs to be pursued or admitted. Depositions, another discovery tool. Depositions are oral interrogations. Interrogatories are written interrogations. Depositions are oral interrogations. the attorneys representing the plaintiff or the defendant have a right to seek depositions of parties and witnesses in a case. And depositions allow for the examination of the parties and witnesses based on the nature of the claim and the defenses. So instead of having a written submission, oral questions are sought, and there's going to be a response immediately at a deposition setting. And the depositions are going to be a live setting where the parties are represented by counsel and have the opportunity to ask and respond to questions that are directed by lawyers. Affidavits are another discovery tool. Affidavits would be a tool where information can be stated based upon knowledge and first-hand knowledge or awareness of certain facts that are stated in the form of a disclosure, a statement. So an affidavit is another discovery tool. And again, there's information in your textbook that really highlights all of this information that you should be aware of. Look on the figure 4.2 in your textbook, and these are typical pretrial motions. I'm not going to go through them in detail here on this PowerPoint discussion, but you should be aware of these different types of pretrial motions, and these are typical or general pretrial motions. For example, a motion for summary judgment. That's a term that you're going to need to know. It's where there's no dispute based on material facts at issue that allows the judge to conclude as a matter of law that the issue has been resolved, where there is no factual dispute. If there is a factual dispute about a material point in the evidence, in the claim, then the judge is not going to impose a so-called summary judgment. You should be aware of what are the advantages for a summary judgment and how a summary judgment motion might be used. Either party has a right to file a so-called motion for summary judgment. It can literally end the trial going forward because there's no material dispute. Now, a material dispute means there has to be a dispute that goes to the very heart or the very essence of the claim. How does a judge determine whether, as a matter of law, there is no longer a material dispute as to the very heart or the essence of a particular claim? Well, that's after usually the discovery process has concluded, where the evidence in the form of affidavits, depositions, interrogatories, production requests, all indicate that there really truly is not a material dispute for which the law can be applied, and in some instances the judge will rule in favor of the plaintiff or the defendant and avoid a part of the trial, or in fact sometimes all of the trial, from moving forward. Again, take a look in your textbook regarding all of these terms, which are in bolded print. All right, let's look next at getting ready for trial. Getting ready for trial. Just like there's a summons for a defendant to come to court, there's also a summons to possible jurors to come to court as well. And a summons is a part, well, in fact, it is a court order. It's a court order. You cannot, if you are served with summons, avoid going to the court and offering your services to serve as a member of a jury. It is your civic duty. It's your civic obligation. And if you violate and refuse to honor a jury summons, you could actually be held in contempt of court and arrested and brought to court, and to show reason why you've tried to avoid your civic obligation by responding to the summons and participating in the jury process. Before you get to that jury process, there's no guarantee you'll actually be selected as a juror for the trial. There's a term called voir dire. It's also pronounced voir dire. It's either pronunciation is fine, but it's a term, and it allows attorneys for their clients, the defendant, the plaintiff, to ask questions of prospective jurors about their views, about their opinions, so as to expose potential bias or prejudice that either the plaintiff or the defendant would want to avoid that person being on their jury. So voir dire is a process. It's a process of examination to allow for information to be brought forth about that particular potential juror. And that's all part of the jury selection process. So make sure, again, you read that section in your text, the jury selection process. I want to talk about peremptory challenges for just a moment. The plaintiff and the defendant are given a certain number of peremptory challenges for which no cause or reason be given to excuse a prospective client. Now let me step back for just a second. A potential juror can be excused when cause exists. Cause exists might show that they know the parties, that they know an attorney, or they might have some bias that's obvious that would show that there's a reason, a cause, why they should not be allowed to sit as a juror, someone who would completely be unbiased and be able to render a fair decision based on the evidence that's presented. Now, there's a number of peremptory challenges that are available, and those challenges differ from courts to courts. Some courts might allow for 3 in a case, 5 in a case. It really depends. But the process of voir dire examination continues until all of the peremptory challenges are exhausted. Each party has so many peremptory challenges to raise. And once that's completed, and once that jury panel, which might be comprised of 12 jurors or 6 jurors, is ultimately selected, then the case is ready for trial. Racial discrimination, and I think we should focus on this aspect too, given what's taking place in our country right now with recognition of race issues and justice issues in our civil society. Racial discrimination in the jury selection process is against the law. And it's been against the law for many years. In fact, the Supreme Court in 1986 outlawed racial discrimination in jury selection in the voir dire process. Lawyers cannot use peremptory challenges that establish a discriminatory motive in selecting the jury panel. And by the way, gender discrimination is also banned in jury selection too. Take a look at another figure in your textbook. It is figure 4.3. And that figure, your authors have identified, again, different steps in the litigation process, but at trial. Voir dire, opening statements, the presentation of evidence through the witnesses. Other aspects, other steps that all form this procedural process that's available in our litigation system. This figure outlining the trial steps, figure 4.3 in your textbook outlining the trial steps, is really a very good, cohesive description or outline of the major steps that will occur in trial. So be familiar with that process. Now, really important, and we're going to continue a discussion later on in different aspects as we move along in this course regarding the burdens of proof. The burdens of proof. The party that brings the cause of action has the burden of proof to convince the trier of fact, that could be the judge or the jury, on the issues involved. In criminal cases, the burden of proof, and I'm sure you've heard this, is beyond a reasonable doubt. That does not mean necessarily any doubt, but just that the doubt has to be reasonable. In civil cases, there is a burden of proof called the preponderance of the evidence, or clear and convincing. Now, clear and convincing proof or evidence of a fact needs to be established for certain causes of action, for example, fraud or misrepresentation, where convincing proof is needed. But generally, in most civil cases, there's a preponderance of the evidence standard. And the preponderance of the evidence standard means it's more likely true than not true. In other words, the claim presented or the issues going forward by the plaintiff must be established by a preponderance of the evidence. It must be more true than not true. It has to move the mark beyond a point to show with the totality of the evidence that the proposition at issue is more true than not true. So please read carefully in that section of your textbook for further information. And again, we're going to be discussing that concept later on in different applications. Deciding the case, again, with these different steps, there are steps that include a directed verdict, jury instructions. Jury instructions are the rules of law that the court or the judge provides the jurors to apply in deciding the facts. Now remember, what do juries do? They decide the facts. How do they know the law? They don't. They're instructed, they're informed about the law by the judge that gives them rules to apply in deciding the facts. Those rules of law are supplied by the judge and are used to ultimately decide who's at fault, who's breached the contract, whether the plaintiff wins or loses, whether the defendant wins or loses, so to speak, as well, based upon the standard of proof which we've just discussed. But the jury instructions are rules of law that the jurors apply in deciding who's going to be responsible, who's going to be liable. And then there's other terms that are used. A judgment, for example. Once there's been a decision or a judgment, then that can be entered as a matter of record. But the party that has lost the trial, if the party believes, for example, that there's overwhelming evidence to show that the jury was incorrectly decided by the the jury incorrectly decided the issue, that there wasn't evidence that substantially showed that the plaintiff, for example, or the defendant should have won, then there can be a judgment notwithstanding the verdict, which the court may grant even though the verdict by the jury was otherwise. And so please read that section, especially in your textbook. And then we get to the appeal section. And litigation continues. In our legal system, parties have a right to appeal to a higher case. So the losing party to a trial has a right to move forward and challenge the outcome of the case if an error of law if an error of law has occurred. So litigation is a process. It's a process that can entail not only the pre-trial, the trial, but also after the trial, when there is, again, another level of review and continued litigation. Look at figure 4.4 in your textbook. 4.4 is the appellate review of a case from trial. Make sure you have a good understanding of, again, all of these different steps that are applicable. So this chapter that or your editors have entitled Litigation is really pretty comprehensive. But it will give you a view that in our legal system, parties have a right to have their disputes adjudicated if they qualify. Once they qualify, then there's a whole process that's involved. And this process can take months, sometimes years to move through the system. But it's a wonderful system, and it's a system that other countries have tried to emulate in many contexts elsewhere. So we have a wonderful system that litigation allows for the pursuit of justice. And it is, however, an adversarial system where the plaintiff and the defendant, they contest each other's evidence and move forward and have a fair and unbiased trial decide the outcome for liability and damage purposes. So I appreciate your attention and your reading through all of this text material. As always, if you have questions or concerns or want to discuss any of these issues that you want to make or you have further concern about, please always feel free to contact me by email or otherwise. Thank you.